Abusuafo native for higher for 1G channel no first time aba so ani di no bu kwan so na wa subscribe am se benye news bia na shi bia obenye notification of phone so na be shafin so e ma fi so be sha more than for so enye beti for me nken some so thing. The lawyer eye tatutu chakana ba bonten na ne nsem oda be godie ese woni ese kacho ye ba kuti mu nsem no e video e kwakohwe na sene wasi disgrace Afenyo man Kesi chief justice ne die ibu campusi da inim say sa asem we ban no eye beka eye tatutu chaka NDC lawyer just we nim the panel or interface eye nsema na ekoso bidin eye the speaker for Babin eye beka Afenyo man Kesi any chief that Tokono e na to engineer kware dey beka hono or interface case we no o school eye Afenyo man Kesi na eye beka chief that Tokono ese go man masino enim say nche bia no ene ebeka eye nkofo ye MPP foi e bra speaker e call am so momra no first one no on stage workout and afin so Afenyo man Kesi dey omo chelete akesi a just a chopen na wo mede e de come speaker say nke be yom nye de omo sametna se bi say no mede omo record for speaker Babin say nkomo nye de omo nyina MB parliament no nya sametna se speaker Babin bia no ma samba na nime si wa outside chamber no na ebeka here to chaka babo ntan beka wansa no kase eye twedie a je se kiti am babo ntin bu twedie ni adade no na ehun hia wo twede nimpa yi na they say no na kiti am join twede ni ma no o kan say o ka chi media say o be san eye speaker content aden a o say eye chi just Tokono ru no de buy no o say e was saying ka speaker de ediso when this into also be san content. And when I beg can't Judicial say, meet me at court. Okra now we are cramming Chawa de Campo law school. So also the paper dear meet me at court. Artist Rebecca, a yet Judicial the ad there and also a challenge a year. Katie among big time punch saying yes and good work. Come in good things in me, of course, a bar needing commotion at also.
Can make pronouncements of the Constitution, is the supreme law of the land. And it's very clear in the Constitution, for instance, that is on account is embedded in that Constitution. So these are really serious matters. And I think that it is sometimes too simplistic for people to give the impression that the Supreme Court has made a statement and therefore, you have to go by it before you complain and so on and so forth. In this particular case, as you know, the Speaker actually took the opportunity of having his counsel go and try to set it aside.
And when he made the attempt to try to set it aside, the Supreme Court affirmed its earlier decision.
Yes.
And I'm sure that you have heard persons like Hammond speak that they were going to cite the Speaker for contempt because he's not obeying the decision of the Supreme Court.
Well, I would like to see that application by Mr. Hammond, Honorable Hammond. I'd like to, he was a student of mine too. So I like to see how his legal professional caliber stands up in terms of whatever he puts as in terms of contempt of court. But you know what?
But when counsel for the Speaker has tried to set it aside and he wasn't successful with it, shouldn't the Speaker obey what the Supreme Court said?
That cannot be the end of the matter because, as you know, for instance, there are rights to review a decision of the Supreme Court. So it can be the Speaker's prerogative to ask for a review. But you see, one of the aspects of what happened when the Speaker's counsel went earlier decision of Chief Justice Archer, in which Chief Justice Archer, as he puts it, came out forcefully in support of separation of powers and the principle of non-justiciability of certain matters in these words. The Constitution gives the judiciary power to interpret and enforce the Constitution. And I do not think that this independence enables the Supreme Court to do what it likes by undertaking incursions into territory reserved for Parliament and the executive. This court should not behave like an octopus, stretching its 8 tentacles here and there to grasp jurisdiction not constitutionally meant for it. So this was what one of the judges said. There are other statements in that case by other judges, all pointing to the fact that the Supreme Court should be careful in not venturing into the territory of others. Now, so when the Supreme Court, without even giving notice to the Speaker, so that the Speaker can at least let his side of the matter be heard, when it does that, it's very problematic. And the Supreme Court, again, has itself said that when there are previous decisions, it has to go by them, because that's what the Constitution provides. Article 1293 of the Constitution, there again, very clear. The Supreme Court is bound by its own previous decisions. Unless it wants to depart by stated reasons, then it can do so. But here, the court did not even make reference to any of these previous decisions because, frankly, they did not give the Speaker a chance to put before them his side of the case. So based on Honorable Afenyo Makin's ex parte application, as we called it, they made those pronouncements about the orders. Now, those orders are also very problematic because when you look at the writ that Honorable Afenyo Makin put to the Supreme Court, he wanted an interpretation of 97(1)(g). You talked about G and H, but in his writ, he actually did not say G and H. He said G. Right. So H, which is about Honorable Esiama, the Deputy Speaker, was not part of what he took before the Supreme Court. People lose sight of that. Right. Now, so if he took G to the Supreme Court, the Supreme Court had no basis for bringing in orders in relation to H. Right. Because that's not part of the writ. Additionally, as I think was pointed out by counsel for the Speaker when he tried to set aside the writ, you have a situation where the papers that were filed by Honorable Afenyo Makin were deficient in terms of the rules of the Supreme Court itself, because the rules of the Supreme Court required Honorable Afenyo Makin to have an affidavit that supports, verifies the statement of case that he filed, because an affidavit involves somebody stating on oath certain facts, and on that basis the court can act. In this case, there was no affidavit, so all that was in the statement of case lacked verification. And essentially, when the Supreme Court in its ruling was talking about things like constitutional crisis and so on and so forth, it was relying on things in Honorable Afenyo Makin's statement of case which had not been verified, and therefore they could not be relied upon as evidence before the Supreme Court. And when you have clear rules which require that for such an originating process you must have an affidavit, again, there is judicial precedent for insisting that in those circumstances the proceedings are void. Right. So they should not have proceeded without at least taking account of the fact that there was a deficiency in terms of compliance with their own rules. So that again is a problem. As I said, there are multiple reasons. But
forgive me for taking you back just a little bit. You talk about invoking the exclusive jurisdiction of the Supreme Court to interpret certain clauses in the Constitution. Are you saying, with the precedents that you gave out, that even in this matter, that jurisdiction had not been invoked?
It had not been properly invoked by Honorable Afenyo Makin's writ before the Supreme Court.
Okay, so then takes me back to the question that I asked you earlier. What would you have had them do?
What would the Supreme...
What would you have had Afenyo Makins, for instance, and the Speaker do?
First of all, the Supreme Court, I believe in this context, using its own rules, should have pointed out to Honorable Afenyo Makin that there was no affidavit verifying the statement of case that he had filed before them, and therefore his writ was deficient, and they could not proceed on a deficient writ. I think that would have been a simple end to the matter. Secondly, if the Supreme Court wanted to give any guidance to a plaintiff who has not complied with their rules, they would, again, just refer them to the rules and give them the opportunity, if they thought appropriate, to correct those. Because, again, the rules of the Supreme Court will make it clear that non-compliance shall be a bar to further proceedings unless the Supreme Court waives that. There's nothing in the record which tells us that the Supreme Court waived anything by way of, sort of dealing with a non-compliance that there was, just on the face of things. So then the reason all these things are important is not just because of technicalities. The reason these things are important is because the rules enable us to ensure that things are done properly in an orderly fashion, and that whatever then comes authoritatively as a pronouncement of the Supreme Court is an appropriate authoritative decision that we can all go by. But where we see so many errors in terms of how the proceedings have gone, it just undermines the authority of the Supreme Court. And, this is really important because, again, as I said earlier, all of us have a responsibility to respect the Constitution and to ensure its enforcement. So, for instance, if you go to Article 3 of that very Constitution, it makes it quite clear that if any attempt is made to go against the Constitution, we all have a duty to resist it. Mm-hmm. And that attempt can be made not just by people wearing military uniforms, it can be made by people wearing wigs and gowns as well. So we really have to take seriously our responsibility, all of us, to be familiar with what the Constitution provides. The Constitution is not just some arcane set of words that lawyers can, indulge in, and that judges.
For lawyer Chatuti Chaka Ababontin, Ababeka, Senior was dating, or say MPP free, including Katie Hammond, Afenyo markings are the leader of a Beka, the minority right now, also respected the Constitution. And near my course of Parliament, or stated some article B, say, any Kwanzanga Supreme Court riding. Like, or stretching the arms comparing Eba Sasim Mukampo. Say, a friend of mine is this Sasim no Campo Bow and so on, riding Kobotugu. I don't know, or stated some maybe say, don't behave like Octopus to stretch your arms to venture into Parliament. And how we had did see more of me, pa. I just say no, and I hate to check hiding. I stated some a statement be Eddie Chief Justice Tokono any mass bar because according to the Constitution, near my course of Parliament, because your three arm of government will be an ejuma. So it might interfere one arm of government now. I was so heading or bar or like or mentioning the 1 year, they more better sense and a cake. But a chief that took on a barber in the or sending ruling and I speak about being fine ejuma. Now so and like any sanity, Abia my being chilling ye. Simple. Now my country says ruling out there, but I was a speaker ediso. I know that to check a go any massive point to say, Yasim Kutua. Or we no can say speaker ruling no come up. I was a speaker and a rules are a case we. And all this some a simple analysis behind the tuja analysis and what could say if you want to say more just say a more me pa constitutional or in crisis no I say vacant chief judge the Bible in vacant assembly or say dear the entire chief judge took on a cancer assembly say a based on a Afenyo markings case no the bar into the or cancer assembly Newz and meet the press na vacant a speaker about any media phone meeting no or reply no. And at a year back to check on writing about when I reply no. Coming could say about to get back
decisions of the courts themselves, including the Supreme Court, decisions which make it absolutely clear that you don't, under the guise of interpretation, take to the Supreme Court things that are within the preserve of other courts or other authorities in the system. Very clear decisions. And I think we have to have a little law class here because because I like some of these passages from the decisions of the Supreme Court itself, to be laid out for all of us to look at, because all of us have a responsibility to protect what is in the Constitution. The Supreme Court is not a law unto itself, fortunately. Neither is the Speaker a law unto himself. We all have responsibilities. So when, for instance...
Would you then say that the Supreme Court erred in that?
Well, definitely, in many respects. In fact, as I will try to perhaps explain if there is time, it erred in multiple respects. As I said, in the first respect, just running and saying there's a matter of interpretation, therefore Supreme Court, I'm before you, is not acceptable. The courts have said in many cases, there's this case, for instance, Eduamwa and Chum, where it was stated, Aqua, the Justice of the Supreme Court, as he then was, makes the point that all courts, tribunals, institutions, and all individuals are bound by the provisions of the Constitution in the adjudication of disputes before them. In summary then, whereas the original jurisdiction to interpret and enforce the provisions of this Constitution is vested solely in the Supreme Court, every court and tribunal is duty-bound or vested with jurisdiction to apply the provisions of the Constitution in the adjudication of disputes before it. And this jurisdiction is not taken away merely by a party's reference to or reliance on a provision of the Constitution. So just running to court and saying, Supreme Court, I want you to interpret such and such for me, does not mean that the Supreme Court should go ahead and do that. The Supreme Court has to decide whether it has jurisdiction. And I'll give you another example of something that
But I thought that interpretation of the Constitution is the exclusive jurisdiction of the Supreme Court.
Yes, but the court itself has made it clear that that does not take away the responsibility of others to apply the Constitution. Every institution, every court in the land applies the Constitution. Right. In applying it, they have to understand it. They have to interpret it in that sense. So the courts have made it quite clear that when you talk about the exclusive jurisdiction to interpret, it is not everything about some provision of the Constitution that leads to the requirement of interpretation. Do you see what I mean? So
there has to be some parameters that has to be met.
Exactly. And those parameters have been set out in judicial decisions of the court itself.
Right.
And basically, those earlier decisions of the court itself. I think it's
ex parte accusa.
There are many such decisions. Right. That's exactly one of them. But there are even more recent decisions, like when the Ghana Bar Association tried to take Chief Justice Aban's matter to court, and they tried to say that Chief Justice Aban should not be a Chief Justice because he did not meet certain moral standards and so on. They took it to court. And it's interesting what the Supreme Court said in that case, because in fact in that case they made very specific reference to the fact that Parliament should not overstep, the Supreme Court should not overstep its bounds, especially when it comes to parliamentary matters. And
Tsikata, in this instance, I know that you're trying to find the judicial decisions for me.
Yes.
But in this instance, where it appears that there's some misunderstanding, for the want of a better word, on what the provisions of Article 97 G and H means, what would you have had the Speaker or even the members of Parliament do?
Yes, let's go step by step.
Okay.
I'm saying that the Supreme Court, when it is faced with a matter in which somebody runs and says, interpret,
right,
they don't automatically say there's an issue of interpretation.
Okay.
The court is guided by its own precedents,
right,
in which it talks about what qualifies
an interpretation
to invoke its exclusive power.
Okay.
And they make it also clear that other courts also have the responsibility to apply the Constitution. And of course, in applying it, they also do something that you can call interpretation. But when we talk about the exclusive jurisdiction, it is based on certain parameters. So here's one of the statements that was made in the Supreme Court in respect of the urban matter, for instance. You know, the statement was made very clearly in the judgment of Justice Bergan. He makes reference to another.
So, edify a Supreme Court, you know, or more stretch or more arms, interfere into a ruling a course of parliament, you know, and on a lawyer that you check out and about thing. I be go many massipa. I church or school or say, don't behave like all toppers. All toppers the or arms be with me stretching the arms and better baby. No, and I'm assuming him say in him sabuano. And no, I can't a chief that took on us and Nicholas will behave like that. Or catch a Supreme Court say Nicholas say behave like that. Chief that took on us, yes, I wasn't quiet. Afenyo mark in so our parliament, you know, any quans or the ASR assembly at the court. So the court component a court and to Mukadi are fine. So court a can be there. I was say or no did not drink chereba. Name and by force or no ruling on the or diabano. On following by force. I know I'm a to check it and Bible team. I didn't see my big go. About a year crisis a year constitution woman and chief as the Bible in Tibet. In him send me the president a year became a year. The speaker about Barbie, you know, a Bible in my reply no. A year to check out about pointing so about reply a chief to Tokono. I did find him maybe a course of Supreme Court any a year Parliament and you can go Casas and no campo. Because Afenyo Markins case not the bar no wasn't commander on board to go. Senior was say go Afenyo Markins any mason, any chief that took on any masons or any asim the tour. In him say a year speaker and Barbie, afraid the second time now, a year Afenyo Markins, Adelaide Takisaki say educated than domain in our national. A idea almost a free beam no. The majority side now, a Becca a year NDC for quite sign and internet man air from your markings, no, and any or mom can chita for the armor parliament, no. I speak my barman say, while joining a year parliament meeting, no, indefinitely, and as I was suspended. Ninja name, a brand a outside the chamber of a parliament, no, na KTM or airboard Kesi. Now the Casimono and our catching media for say. So far as I Yebeka, the speaker about Barbing, emphasize and this Supreme Court a ruling is no or best for contempt. And no, and achieve a year Chaļļenģes a catching say, oh, now or make shower dear or crack it to go and make shower dear, meet me at court. So also this has my body and meet me at court. I don't know, I'm a challenge your drama, a kitty, I'm on a yasam good one. Okay, can't see me beat my dad, share or comment, such beat him, so I share. I'm more down for so, and you be a higher for 1G.